Okay, we're live on all 4 channels. Welcome everybody to today's episode of the Day's Tip. Really excited about today. Actually, there's certain guests and chats where I've spoke to the person many times, and also have a more of an experience myself in that field. And I think I bring the person on more because I want to get the viewers to learn from those people. Whereas today with Chris Fryan talking about human rights and law, I've got that bits and bobs I've read over the years and been exposed to just from a lay sense. But I'm excited to learn lots myself today. So thank you for joining us, Chris.
You're welcome. It's nice to have someone excited to hear from me.
Yeah, it must be a interesting line of work that you do. I'm sure a lot of the cases and the clients are in difficult situations, and it's probably not always the most morale boosting work that you're doing, right?
Well, I mean, it's better when we can. When people come to us, it's usually in a really tight spot, because something's wrong. And but it's always, the work, it has that feel good factor in that if we're doing our job right, then we're improving something, so we can turn it around fairly quickly. I think it's more people we write to that I expect are not so excited to hear from us these days. So we're not every email I send I expect to be warmly received, but I hope at least my clients and supporters take a different view.
Let's start from the beginning. I mean, I've sort of referred to human rights and law, and there's some of the ticker tape going down the bottom of the screen as well saying so. But could you give an intro, Chris, to who you are and a bit of your backstory? It'd be great to start off there, I think.
Sure. So, normally I'm used to talking about cases and other people, so it's a bit of a novelty to be asked to talk about me. Probably not so good at that. I'm a Yorkshire lad, Sheffield born and bred. Increasingly spend time working, or up until this crisis, we're spending a lot more time working in London. And we have a national practice which covers disability rights. Majority of the work is about is in the sort of consumer context. So we do a lot on achieving reasonable adjustments for people. That could be in the context of businesses and customers, but also students and universities. And increasingly, we're involved in public law challenges where we think that decisions are being taken without due regard to the needs of people with disabilities. So I've been doing this work since just before the Equality Act came in. Actually, I did my first case for a deaf student at a university up north who was experiencing difficulties with reasonable adjustments. And then from 2010, I started engaging in this work more as a work type through Unity Law. And then in 2017, set up Fry Law. And at the moment, pretty much everything we're doing is disability rights specific. So we do that we've always been prepared to do it on a no-win, no-fee basis, which is a horrifically bad business model, but is really necessary to help people, because ultimately, people can't afford to. Who can really afford to instruct lawyers? And this is a very complicated area. So I think my early days were working as a lawyer specializing in workers' rights, and so we did lots of occupational noise damage and industrial cases for people who actually then became disabled as a consequence of their condition. And I think so. I qualified in the year that no-win, no-fee agreements were introduced. So from my perspective, it's always seemed like the best option for people, even though from my perspective it's clearly not, because we only get paid at the end and only if we win, which is you do that.
I can see that it would be challenging. So we've got a couple of people. Thank you for that, Chris. That was great to sort of hear a bit more of your your personal side, and we'll get stuck in a bit more into the meat of it in a second. But a couple of comments coming in. So Gavin from Neatbox saying, great to see Chris. Important that our soft voices have an effective stick on standby.
Yeah.
And Chris says, hi. And the other Chris Wood says, hello, morning, chap. So good to see everyone joining on the live stream. Obviously, get any of your questions or thoughts coming in as we're chatting. So yeah, I think for me, Chris, as I said at the beginning, like obviously everyone has interaction with the law and with legal things in the news every day. It's not like a hidden point, but I think obviously there are a lot of parts when you get right into it, it's very technical, and that's your role as a lawyer, to help people to navigate that and understand that. But if we were in the pub, like pretend we're having a pint now, what would your sort of way of explaining the law, and what laws are you working within? Because there's the British law, the Equalities Act, but there's European laws. So just a bit of an idiot's guide for someone like me on how sort of the law works in a consumer way, in a workers' rights way.
Well, I can give you the simplified version because that's how I work. I ask the technical, difficult questions about the law, then I work with barristers to do that heavy lifting. But in general terms, my work is as a solicitor. I build the cases, so I'm the point of contact for a person who needs our help, and I'll work that case all the way through up until make sure the right building blocks are in place, if you like, up until the case needs to go to court. And very few cases still actually end up going before a judge. Most cases, overwhelmingly, are compromised once they get to a certain point. So the cases themselves are brought under the Equality Act. So the Equality Act applies in England and Wales. So we're working with the legal jurisdiction. Scotland's a different legal jurisdiction. So whilst a lot of the same principles apply, the way in which you run a case is different. The court system there is different. So we specialise in working within the arena of the law of England and Wales. What we will do is typically bring a case under the Equality Act for a failure to make reasonable adjustments. So a person is disabled, or if a person is disabled, they have a protected characteristic, which means that service providers are expected to do more to adjust their services to promote inclusion. It's fundamentally it, which is not just morally the right thing to do, it's often commercially the right thing to do as well. But there's a lot of misinformation about that. So things like, I can't have a ramp here because it's a listed building, that kind of myth, which is often wrong. So the law is, you have a protected characteristic, you can bring a case under the Equality Act, you can expect a service provider to make a reasonable adjustment to accommodate you. And that reasonable adjustment might be in terms of access to a building, or it could be access to information. So there's a lot we're doing at the moment about inaccessible communications. It could be about policies or practices which inadvertently discriminate or have a more gross adverse outcome on disabled people. So we can challenge those practices. So we've done cases about pricing policies which are discriminatory. We're doing a challenge at the moment involving disability rail card. Potentially, it costs more for a disabled passenger to travel because they need a carer or a support worker. So the basis is Equality Act cases, Equality Act. We will do those cases through the county courts. We expect that those cases usually get compromised, but cases which go the distance tend to then change the law. And one person with the rights given to them under the Equality Act can change the law and change a national practice for good, for the benefit of thousands of others. So one case that springs to mind there is where we challenged bus companies for having a wheelchair accessible space, but then not keeping it accessible for wheelchair users. So the existence of a space was a reasonable adjustment. But when it stopped, ultimately allowing anyone to use it meant that it was no longer a reasonable adjustment. And so through a case we ran with Doug Pawley, who's now a celebrity in his own right on disability campaigning, we got that case all the way up to the Supreme Court, changed the policy, and that policy has provided a more, or should be providing a more inclusive solution for disabled transport. So those cases all start out the same way. County court, overwhelmingly the majority of cases resolved without the need for even court proceedings. But there seems to be a lack of awareness of rights. I think a general concern that the legal process is impenetrable and that lawyers are unapproachable. And I hope that what this does, and the experience of others we're working with, will show is that actually couldn't be further from the truth. And hopefully COVID will have a positive impact, because we're doing so much more now in terms of Q&As and live sessions like this, that I think hopefully people will see, or will be empowered. That's the hope.
Yeah, no, brilliant. And interesting you said about the sort of silver lining around COVID. I mean, everyone I've spoke to on the Daily Show here, from all different backgrounds and professions around inclusion, there's generally always been a positive side. Of course, there's lots of worries and there are negatives of COVID-19, 100%. So I keep having to caveat that, so we don't get miscommunicated. But there are definitely a lot of positive silver linings. So it's interesting you're seeing that in the legal profession as well.
I think it's making us more accessible. We are more accessible now through Zoom conferences and sessions like this, which has got to be a good thing, because at the moment, there's so much of the rest of the world which isn't, and there's so much. There's such a serious need to make sure people realise that they're not alone. The Equality Act hasn't stopped. No rights have been suspended. I think the fact that businesses are having to change the way they deliver services in an emergency situation doesn't mean that they can be excused from complying with the Equality Act, for example. And so I think there's a need for people to understand that. I think there's a need for businesses to understand that they need to think equality and disability and reasonable adjustments as part of a decision-making process when looking at altering any service, or in fact delivering any service.
Yeah, I mean, there's quite a few questions coming in, as I thought there might well be. And I have a feeling in the end, whatever the context or the section, like whether it's public or private, have a feeling the legal route is going to be exactly as you've described right there. The Equalities Act covers all of it. And then if there's a breach, you can take that to the county courts, etc. But we'll still sort of go into some of the questions that have come in. So Zara on LinkedIn is asking about education, particularly the building systems and virtual access to education. So are there any cases that I know obviously you can't talk about individuals, but are there any sort of broader things that you've worked on already, or general thoughts around how to make the education more accessible using law?
Yeah, so I mean, we saw a very substantial rise in the number of education discrimination cases, particularly in universities and higher education, over the last 12-18 months. Mainly, I think, because the generation of students going to university now came up with rights that were given to them under the Disability Discrimination Act 95. And so I think the younger generation understands that they have more rights that they can enforce, because they've been through a slightly different system than older people with disabilities. And because they're paying £9,000 a year for a service and they want it to be there. And and it's understandable. But my experience of that is that in those cases, there's usually a really good upfront assessment as to what people's needs are. So there's usually a really good sort of support assessment made at the beginning, and that failures come really on implementation in workshops and lectures, and those go wrong more often in cases with hidden disabilities. So the students who need information providing in a different format or in a different structure or in advance, they're often overlooked. We did a case for a student who was incredibly bright. I think he was doing astrophysics with Asperger's, but he required, despite the fact he clearly was very intelligent, required assistance in the way in which the course was taught. And I think the working assumption was, this guy's having a laugh, and he doesn't need all these adjustments. And that some of the responses which he thought were funny were considered to be disruptive, for example. And ultimately it broke down to the point that he had to leave the course and do something totally different. Very expensive mistake for the university, who had to pay compensation for the injury to feelings, but also had to contribute towards a delay in that person qualifying from university and pay back tuition fees, for example. So we see cases like that. I think most campuses and university sites seem to be accessible, so they seem to be good at identifying needs for wheelchair users. We don't see many cases of inaccessible workspaces in that respect, although sometimes we do see cases where lessons are put in an inaccessible part of the campus, which needs sorting out. So the basis for those cases is the same. It's usually universities recognizing that there are rights that they have to make reasonable adjustments, but then them breaking down. So it's in training staff about that, and just recognizing that communication needs to be better. One of the problems we have is that in terms of the Equality Act and the way it's enforced, that legal fees are only recoverable in higher education and university cases. So you'll see lawyers like us able to do the work because we know we're going to be paid for it if we win. Whereas the current system's structured so that cases up to that level, so all through primary, secondary school education, are put through an educational needs tribunal system, which I think is not a level playing field, and something needs to be done about it. In that those are particular, very bespoke or niche sort of setup, and parents are expected to go in there and make arguments they'll be making for the first time, quite complicated legal arguments a lot of the time, against experts who deal with these funded by local authorities day in, day out. And so that's an area where there are way too many people having to litigate in person in an alien system in a complicated area, because the law doesn't provide for recovery of solicitors' costs. And I think that needs to be addressed. There are some fantastic education teams of lawyers publicly funded through legal aid that we refer cases through to, who obviously can help. But I do think that's the system that needs tweaking up in terms of education.
And where would that change come from? Would that be a government policy?
Yeah, it would. And I think clearly the idea is that they want to keep costs down in the education system, in that, you don't want, if you add in a layer of extra legal fees, then that money's going to have to come from public funds. And so, you can see why it's attractive to try and find a slightly different mechanism for resolving those disputes. But maybe the answer is to provide better public funding, or relax the rules and allow lawyers to get involved on a no-win, no-fee basis.
Yeah. Okay. So thank you for that. I mean, I'm sure there's an hour's worth of educational related, thoughts and everything, but I think that addresses education as a sector and as a question for now. There's a couple coming in, like Sarah, saying around someone needs to bring a case against the government currently for inaccessible info during coronavirus, and there's a couple of other things on LinkedIn mentioning the government and coronavirus. So maybe as a broader, what's your take on those two factors at the moment?
Well, Sarah's right. Someone does need to do it, and it's us, in fact. So I've been involved with the Where is the Interpreter campaign in order to try and press home that the Prime Minister's live national daily addresses need to be provided with BSL English interpreting support on that platform at Downing Street.
Yeah,
that's what happens. That's what happens in Wales, in Scotland, pretty much everywhere else now. In New Zealand, they have the interpreter on stage, and there are so many advantages to that. First of all, it shows that the government considers that accessible communications for deaf people for whom BSL English is their first language, that their needs are important, that the government considers that that's mainstream thinking, and from a social and moral perspective, that would be a really big positive. So it's disappointing that hasn't happened. We are involved with a campaign there, which is using public law principles to say that failure to provide an interpreter, failure to provide a reasonable adjustment under the public sector equality duty. So there should have been an equality impact assessment undertaken prior to launching those addresses, which should have considered how various people might need assistance with accessing that information. And I've asked for copies of that and haven't been provided with them, so I suspect they don't exist. Although if the government legal department are listening, and they do, please send me a copy, because there are 80,000 people for whom BSL English is their first language, and just can't be locked out of this information. For the first week, more or less, I think the first week of these briefings, there was no interpreting support at all. And those were the most important. For me, I found that first week of briefings the most crucial, because I was worried. Millions of people, many of us, worried about this new epidemic. And so we're challenging on that to provide better accessible communication at that level, both in terms of county court cases for damages and at policy level at the top. So we're taking that fight on. The other thing we're doing is we're concerned about blind people and people with sight loss and visual impairments receiving letters which they can't read, and the lack of consideration for providing information in an accessible format. So I'm acting for a client of mine, Dan, who he receives benefits. He receives access to work because of his sight loss, because he is blind. And so the government somewhere knows that, the system knows that that there is somebody with needs at that address. I received.
It's not rocket science, is
it? I don't think it is. I receive texts from the government. Why can't the government provide information through to blind people in an alternative format? You know where they are. Don't send them letters which they can't read. All that serves to do is to increase levels of anxiety and feelings of exclusion, because you're receiving a letter from the government with a leaflet in it, then it's because it's important, and you can't. You could just provide that in a different format. It'd probably even be less expensive to send a text or to send an email than it would be to send that letter out through the post. So in terms of accessible or inaccessible communications, we are picking up that challenge, both for people with sight loss and hearing loss, and hopefully we'll see some change. As with many of these situations, the cost of making the reasonable adjustment really is often very, very modest. And when you balance that against the the reward, it's a no-brainer.
Yeah, I totally agree. And in terms of reasonable adjustments, Chris has said, question, do you think the reasonable adjustments is too grey? Is now not the time to give it some black and white definition?
I don't think it's possible to give it a black and white definition. I think it was left in the language it was because it's an elastic concept. There are so many different scenarios where reasonableness could be affected. So, for example, what might be reasonable to a multinational restaurant franchise, for example, might not be a reasonable adjustment for the local, small local deli. So, if the cost of installing an engineered solution for access is so high that it would essentially put the small business out of business, then it's unlikely to be considered reasonable, for example. Whereas, a large company with deep reserves and or deep pockets, would be considered to be caught by that adjustment. So, just using that sort of basic analogy, I think reasonableness is. I mean, so many arguments are fought on what's reasonable and what isn't. I can see why people are attracted to sort of narrowing that category down, but I really don't think it can be. I think, the criteria is, or the surrounding case law and guidance as to what might be reasonable in a particular context is probably about as far as you can go. I certainly don't think you could really reword the Equality Act definition.
Yeah, no, that makes sense. I mean, Rich is asking, we'll bring it up on the screen, why isn't disabled access enforced like a hygiene rating, or is it? And I think that's sort of back to the similar but different, isn't it? That it's very hard to put one stamp on everything. It's that reasonable is in relation to the context.
I mean, I think there are various applications. I think, and I've seen services rated. I think you could do that. You could rate a service through various things, Trustpilot or anything else, and rate them on accessibility. And I think, there's absolutely no reason why disabled customers shouldn't be, publicly rating services, and I think also celebrating services which are really good and accessible. Because although Gavin earlier referred to me as a big stick, actually what we're really looking to try and do is to show the benefits of providing more accessible service. And if you can show how other organizations have tackled this successfully, then those examples need to be shared. Ideally, what you want to see is businesses that have made reasonable adjustments receiving, generating much more income as a consequence. So I think there's a means of sort of sharing information about accessibility in a positive way. In terms of enforcement, I think local authorities could do more to audit and regulate service provision that comes under their jurisdiction. So, for example, let's have a think about taxis. So we're running lots of cases for guide dog users who are typically not picked up by taxis, and they have a right to claim individually under the Equality Act that a service hasn't been provided by the taxi company. But actually, the local authority also has licensing powers over those individual taxi companies, and I think in those situations we could expect better from some of our local authorities in terms of making sure that when they're giving licenses, they're working in certain minimum standards which are scrutinized in terms of accessibility and inclusion. And I think that goes for housing and planning as well. I've had cases where accessible shops have been taken over and made inaccessible, and local authorities ought to be careful about how they manage that. or if a building use hasn't been changed, people trying to get out of the duty to make a reasonable adjustment there. So I think enforcement, there could be better enforcement from local authorities and public bodies through those mechanisms, which would certainly take a lot of pressure off individuals in having to spend their own time and energy in trying to fix the problem themselves.
Yeah, we've got a couple of comments coming in. So Gavin, I have a feeling Chris is going to be a very busy chap in 3 to 4 months if he isn't already.
And
Sarah,
Gavin and I had an online chat a couple of weeks ago now, I think, and the focus of that chat was on a variety of things, but one of the things that's changed since then is issues with access to supermarkets, for example, and I think the issue there is that, well, I'm being kept very busy by that. We put a free guide to how to complain together, which gave supermarkets an opportunity to understand with legal backing that they had obligations to disabled customers. And despite that, the feedback we had, that was downloaded over 350 times by individuals and disabled people's organizations. And so I know that letter's been sent, hundreds and hundreds of times. And the feedback we received was, "Oh, sorry, we're not accepting email complaints to our inboxes because we're too busy." So essentially nothing changed. And so what we're doing there is now taking that the next step. So right now the team here is processing over 200 cases for what's shaping up to be a bit of a class action on disability, in terms of making sure that supermarkets are providing better services to disabled people. Now, those obligations have existed since '95, essentially, and the duty to make reasonable adjustments is an anticipatory one. And I think what we're seeing now is, as the system's being pressure tested, all the issues that were missed by businesses, in this case supermarkets. So we've got cases for people who are blind who can't access the shopping trolley, or can access the shopping trolley facility on an online shop, but their screen reading technology won't apply to bookings, so can't make bookings. Those websites are inaccessible. There were supermarkets who put customer services numbers in, telephone numbers in, as the means to register as disabled, which obviously took out the ability of people with hearing loss or speech impediments to be able to communicate. Queuing systems, we've got people who can't physically stand in a queue for 40 minutes, requiring them to do that. Wheelchair users who are able to actually access stores, having difficulties with reaching shopping on the top shelf, and who are not being provided with assistance. Guide dog users who are not allowed to take in guide dogs, can't shop physically in store without assistance from somebody. People who need assistance in terms of communication, but only one person's allowed into a supermarket. So all of these things are not, are essentially Equality Act breaches, we say, and we're trying our best to do something about that. So you're right. We are really busy at the moment. We've got that. We've got the damages cases for interpreters. We're about to launch a judicial review pre-action correspondent letter through to I think probably either the NHS or the Secretary of State, on the basis of guidance that people can't be admitted to hospital with a support worker, for example, which is problematic as a blanket policy. So lots going on, for sure.
So there's a question I'm going to come back to where you've just left off in a sec, but just Sarah was saying a group in Wales have started building this with the Welsh government involvement, and to speak to Simon Green, if you don't already know Simon Green, as he's a dominant figure in the process. So that's one more directly for you, Chris. But I mean, coming back to how busy you are, I think you've said the word team. So obviously there's some people behind and around you. It's not just you as a one-man band, but nonetheless, I can hear and see how busy you are. What keeps you going with this? I mean, obviously, partly it's your career and its job and that stuff, but is there anything else that gives you the passion and motivation to make this better for disabled people?
I think it's I've always had a fairly strong sense of sort of social justice, to be honest, and it probably stems from the fact that I'm only 5'5", so I was always the shortest in the year, and was used to being chased around and finding myself in situations where I had to negotiate myself out of trouble, really. So I've always sort of had a sense of what's right and wrong, and standing up for myself and other people. But I mean, back in 2003, so I was a fairly newly qualified lawyer, doing lots of exciting stuff and changing things for people. And just as my career was in its ascendancy, I was suddenly diagnosed with a form of leukemia, chronic myeloid leukemia, and that immediately took me out. I had to spend 3 weeks in a hospital bed at the Royal Hallamshire Hospital in Sheffield, and thought, actually, I wasn't so worried about myself, because I just thought, well, I felt like I was going to be okay, and I had some amazing care. Although I was told that I had the highest level of white blood cells in my blood count of anybody that had seen and that had survived. So turns out so it shows how competitive I am. but that, I remember the thought, my primary thought at that stage was, oh my God, I'm going to be written off. My career's written off. And I had partners from the law firm I worked at the time come and see me and give me that reassurance, but which was fantastic. But it made me realize that actually you can be labeled. Having a disability labels you and defines you in a way which I think is unacceptable. And so from my own perspective, I didn't want to be known as the guy that has leukemia. And in fact, up until talking to you about this now, I've never outed the fact that I have this underlying condition, because actually I wanted people, didn't want anybody to define me or the work I do on the basis of, oh, it's that guy with with that leukemia who does this work. I wanted people to wanted to be given the same opportunities as everybody else should be. I wanted to be able to achieve that success in my own right, based on the quality of the work that I do, and not for any other reason. And so I think my motivation is really that I was given those opportunities, and I feel very strongly that other people should be too. And I think fundamentally I'm in a place now where I can help to change things for people in a way which does avoid and is making some progress in terms of where people are seen and treated. So that's what essentially got me. I think I really only started to piece all that together for myself in terms of motivation over recent months, really. But fundamentally, that's the basis. That's the driving basis for what I do. I think it stems all the way back from being that person that has to stand up for themselves to now being the person that stands up for other people.
Yeah, thank you for sharing that, Chris. That's great to hear. Obviously, health-wise, that you're doing well, as you say, like a good challenge and a bit of a fight in all walks of life. And I think you've pointed to a couple of interesting dynamics there as well, that in an ideal world, you shouldn't have felt concerned what your colleagues would have thought of knowing you have a health condition, and that's sort of part of the work going on societally, that, as you say, in the end they were very cool about it and it was good. But I know there are other people, and in other professions that maybe didn't get that warmth and that support. So that there's an element there that it's important we keep encouraging employers and industry to understand the talent and value of people with health conditions and disabled people. But also that the other side, I know Gavin and I have chatted a few times that he almost feels like, because he doesn't have the disability, there's a side of the disability rights movement that doesn't, and I don't think this is actually necessarily happening, but it's a concern he has, is how embraced he can be. And I think it's just so, for me, inclusion goes all ways. So it's like, with or without health conditions, we all want to have that social justice radar beeping, and to make sure that inclusion is there. And it's those labels can be good and empowering, but they can divide and cause issues, both sides of it.
Yeah, so I mean that's really interesting, because I mean we've number of people I've acted for in the past sort of have different views on this, including some people feel that it's disempowering to instruct somebody else that doesn't have a lived experience of disability, for example. And I can see that, but I, on the other hand, haven't wanted to use my disability as a reason to instruct me. I can also see how we get pushback. We definitely get pushback from some people who think the only lawyer that I need a lawyer that has lived experience of disability, of my kind of disability, to be effective at representing me. And hope, I mean, obviously our facts speak for themselves. We've acted for people with almost every kind of disability need diagnosis. But I think I think ultimately there are issues primarily between people with physical and more visible disabilities and hidden disabilities as well. And that what we certainly need to keep away from is a world where one group deserves priority over another. The work we're doing is about fundamentally providing inclusive solutions for everybody in accessing a service. And it shouldn't matter what your impairment is, and there is no sort of priority order. I mean, that sort of leads me on to another topic I'm ranting a lot about at the moment, which is the way in which the government's extremely critical vulnerable persons register threatens to take that discussion up a level. In that, whilst it's there for the best of intentions, only about 10% of people with disabilities in the UK will qualify under that. And the definition of disability under the Equality Act should not be seen as being raised to that definition of qualification for priority services. So, you are disabled if you have an impairment which has a substantial impact on your day-to-day life, and which you've had for the last, at least 12 months. That means you don't have to be extremely clinically vulnerable to have the protection that the law provides under the Equality Act. And my concern there is that what that does is change a classification. It starts to classify disability as something that it's not intended to be. And that from a social perspective, that's something we need to be quite worried about. It comes out to the point you've just made. But also from a legal perspective, whilst I can see it's a starting point and it helps with unlocking the issue, it's not an excuse for supermarkets, for example, to say, because you're not on that list, we're not making a reasonable adjustment for you.
Yeah, very, very good point, Chris. No, it's really gets you thinking, doesn't it? All the consequences. We all know that when politics is the meaning of, in terms of the parties and vying for votes. You know, it's sort of, there are sometimes agendas and the way they frame campaigns on purpose. And I don't know if and when and how much disabled people go through their mind, but it feels like a lot of the issues around disability and inclusion is just lack of thought. Like, it's just not even on the radar, despite the fact there is the Equalities Act, which, as we've discussed through this chat, is there to enforce, you know, when it's breached. Just people just don't think about it when they're planning, which is crazy.
I think you're right. I mean, I very rarely see cases, I very rarely see policies or practices which are deliberately crafted to exclude people with disabilities. It's usually just a lack of awareness. That's it. I mean, it's usually a lack of awareness. But the problem comes where people don't take ownership for that and start to fix it. And once people decide that they're going to lose face by changing a policy, that's when it goes legal. And you know, that's just a mindset. But I agree. Not, you know, it's really that decisions are often taken, in particular in the current climate, very quickly. And what we're learning is that, you know, that actually disability rights are not as mainstream as we hoped that they were, because they're not the primary consideration as they're required to be. They're an afterthought. And I think that's exactly the case. Coming back to the BSL English interpreting point, you know, I'm sure that I'd like to be sure that government isn't just deliberately, you know, refusing to provide it because they don't want to lose face. I'd like them to think, actually, you know, we could re-engage and get a massive thumbs up from 80,000 people who use BSL English as their first language.
Yeah, agreed. So, quick question from Chris is just about the UN. Does that carry any weight when enforcing human rights?
Yes and no. So there is the UN Convention on the Rights of Persons with Disability, and so sitting on alongside the Equality Act, which is the domestic legislation, are various articles which assist with essentially formation of policy to ensure, and the UK government signed up to the UN CRPD. So they have to, it's an additional level of comfort, if you like, that the government signed up to compliance with those provisions, which enshrine, you know, more or less, or extend in some cases, the scope of the Equality Act in terms of definition. But in terms of everyday application, the UN CRPD is fairly unhelpful. The Equality Act is the act that the domestic courts follow. We've been involved with judicial reviews, two recently, in fact. One was on the assisted dying case brought by Noel Conway, where we acted for Not Dead Yet. And our submissions were given a lot of additional value by reference to the UN CRPD when it came to interpreting big issues like assisted dying. And also we were involved for Inclusion London in a judicial review on changing the costs rules and litigation to make it easier for disabled people to enforce their rights. And we referred to the UN CRPD there, but in that judgment we were told it didn't really add much to the domestic law. Okay. So I suppose the answer is yes, it does carry some weight, but we haven't got any judgments that say it's any more useful than the Equality Act is.
Cool, brilliant. Well, I've got one more question, Chris, before we wrap up. I think, you know, there are some entrepreneurs and businesses that are viewing, and so Mark Esho's asked a question that I would suggest Mark maybe follows up with you afterwards, because it's quite a specific context for his business. So I think if we sort of leave the business side around, you know, just check that you're not breaching the Equalities Act and be inclusive. And again, if they've got questions, I'm sure there's lots of resources that businesses can go for. But what I'd like to know is if I or any other disabled person is experiencing discrimination and a breach of the Equalities Act in any kind of day-to-day life, what should I? The dog's just come to say hi. What should I or we do? What would your sort of step-by-step recommendation be?
So first of all, try and resolve the dispute yourself. Often just a communication which says this is the impact of this decision on me and other people like me can resolve something quickly. If you're ignored, I mean, and in that respect, we have a free downloadable guide to what your rights are, and we have some template letters which you can use for sending out emails, for example. And so we also help Disability Rights UK with their template letters, for example. So there are resources out there which you can use to escalate a complaint if you think you're being ignored. The threat of legal proceedings is often enough. And in fact, what we see is that most people initially would be quite happy to resolve a complaint just for a change in the way a service is delivered. It's very rarely about the money, although people do, the Equality Act does require that compensation is paid where a case for discrimination is made out. So try and use the resources that are available in the public arena to try and resolve a dispute yourself. If you can't, then there are lawyers like us who are prepared to take on cases. We do it on a no win, no fee. There are also firms and advice centres who have legal aid contracts who might be able to help qualify for legal aid, and if the legal aid fund will cover the dispute. So fundamentally, main thing is don't accept being fobbed off. If you complain that the service is inaccessible and it caused you a detriment, which is an important part to it, you've got to be able to show that there was a consequence to being unable to access something. Don't just accept a 20 quid voucher. Otherwise there's no incentive for those organisations to take issues seriously. We had a case for somebody who was a quadruple amputee, needed to access a branch of it was a branch of Pizza Express down in London, and the buzzer for disabled access was at the top of a flight of steps which she couldn't get to. And she wrote her own letter, sent a reminder and another reminder, and was ignored. We sent a letter of claim, and by return we got a fantastic response. Pizza Express's response was to say, yeah, we're really sorry, we messed this up, and they attached a check. So it just goes to show that businesses often, it's about getting yourself to the top of that pile. Sometimes you need something on legal letterhead to get yourself to the top of that pile. But there's no reason why that really needed our assistance. It was addressed very effectively by them.
Yeah. Okay. Great. That's a really good answer, Chris. And I know, as I said at the very beginning, there's things I'm aware of through being around the block a bit, and I have had to complain, and I have done bits and bobs. But it's helpful to know there are those templates out there of letters, and that there is that guidance as well. Gavin has just said, did they fix it though after they'd replied to your email?
Yes, they did. Yeah. So I'm going to give a big up to Pizza Express in terms of accessibility. They responded exactly how I think most organisations should. And I think where organisations do make reasonable adjustments, they ought to be praised for it. And as I say, if it's reasonable, if one business in a sector can do it, then so can all the others. And if as a consequence that they get more custom, everyone's a winner.
Definitely. Well, thank you again for being on the show today, Chris. It's really been nice to actually just chat with you, because I've seen your face on social media a lot, and I know all the great work you've been doing, particularly the bus case as well was the big one that you mentioned earlier. But it's nice to just to have a bit of a chat. But yeah, really thanks for all the insights and wisdom you've given to all the viewers. Where can people find? You said that Disability Rights UK have got some of those general rights guidance. Is that correct?
You'll be able to. I don't know whereabouts on their website it is. They did a right to participate campaign last year, I think. So the letters were associated with that campaign, and some interesting video testimonials from people who've used them. Or the risk of shameless self-promotion is get them on our website at www.frylaw.co.uk, and you can download those for free. I mean, I have to say also, Twitter's been is a really an important tool for us and our ability to communicate with our disabled community. And so we have a very active Twitter feed. And I nearly forgot, since I'm at plugging stage. Kathy Castley, who's one of the UK's leading disability rights barristers at Cloisters Chambers, and I, together with a team of BSL English interpreters at Love Language, have set up a free online disability advice service, which is now in, I think it's just coming up to being a month old. Which again is free. We had Baroness Campbell on last week and Neil Crowther talking about disability rights issues in healthcare and COVID-19. That's on a Thursday evening. It's called Disability Rights Advice TV, which obviously we need to work on from a catchiness perspective. But that's Facebook Live. We're trying to copy your format to the extent that you've been doing this for years.
More people.
You've been.
We're blessed to have this technology and this software and to put information and connect people. So I'm looking forward to seeing more of your new TV show, and the guests you've been getting on have been great. Like Baroness Campbell is amazing disability rights activist. So good luck with that. Good luck with the cases, and it would be great to get you back on in a few weeks and have a catch up as well.
Yeah, well, who knows where we'll be with hopefully some successes to talk about. And thank you for having me.
I'm sure you will. Cool, pleasure. Take care, Chris. Bye-bye.